Good morning. Deeply. Yeah, thank you. Oh,
The recently enacted Data Protection Act while analyzing it from a governance, IT security, as well as an audit perspective. We'll be speaking on the methodologies that could be used to deploy and adapt these data protection and privacy policies in different industries. So this is what will be discussed extensively during the day. The program would consist of 8 independent sessions and panel discussions on related topics. So to commence our conference on auspicious note with the lighting of the oil lamp, without further ado, let me invite the President of ITA, Mr. Mahendran Shantan. The Thursday dialogue. Tanaka. Another England speaker of ours, Mr. Budikari Alves. Mr. Indika Rajakarna, our Corporate Director. And our Head of Administration, Mr. Shalindra Ansel. On that note, let me hand over the controls to the President of ISACA Sri Lanka chapter, Mr. Mahendran Prashantan, to speak a few words.
Distinguished guests, ladies and gentlemen, good morning to all of you. I know, first of all, due to the pandemic, we didn't have a members event for the last 2 years. We had one on a very limited basis 2 months back. That was a hybrid event, but nice to see all of you in person. And I know the country situation is not that good, but despite all that, thank you very much. And again, I would like to welcome you all on behalf of the chapter. Today's theme is on Data Protection Act. So we have a very eminent panel of speakers today. Parliament of Sri Lanka in somewhere around March this year. So it's been a while, but we wanted to make local as well as international speakers who will speak on, who will analyze Data Protection Act from audit, governance, security, legal aspects. And not only that, we have some speakers who will talk on how the Data Protection Act was successfully implemented in other countries and some of the success stories, and also an industry-wise analysis on how Data Protection Act will be applicable. So first of all, let me thank the sponsors, Innovate. Innovate is the event sponsor. So thank you very much, Innovate, for having trust in us and fully sponsoring this event. I think without you, this event may not be successful. So again, thank you very much to Innovate and some of the other sponsors, Synetcom, Cyber Labs, and LOC Technologies are co-sponsors. This event will actually fetch ISACA members 4 CPs, and other professional members also will get the equal CPDs. So don't worry about that. Based on your registration, we will send that to the relevant coordinators. So I don't want. And there'll be a panel discussion which will follow. So please sit back, relax, and hopefully when you go out of this room, you will carry a lot of knowledge with you. Thank you very much.
Give us about 2 minutes, your introduction is going on. I think you're on mute.
Shall I put my slides? I'll put my slides.
Thank you, Mr. Mahendra. Next, we have a very special guest here with us to deliver the keynote. I would say, I would reckon that he's a gentleman who doesn't need any introduction. Anyone would know him if we call him the father of cyber law, data protection, and privacy in Sri Lanka. So he's also an international acclaimed veteran in cyber law, not just in Sri Lanka, but all over the globe. So I take this opportunity to welcome Mr. Giant Fernando. Mr. Giant Fernando has over 2 decades of international experience in a range of ICT legal frameworks and policies. He has a specialized master's and LLM degree in telecommunications, ICT, and internet law. He's pioneered drafting of several legislative digital transformation. It includes electronic transactions, digital and mobile payments, cybercrime, cybersecurity, you name it, anything to do with cyber law. It's Mr. Fernando that we go to. So he actually gave leadership to Sri Lanka's entry into the Budapest Cybercrime Convention in 2015 and the UN Electronic Communications Convention also in 2015, both first in South Asia. This is not just an achievement for Sri Lanka, but for South Asia as well. For the past 10 years, he has shared operational responsibility for the East Sri Lanka Development Project, the flagship ICT development initiative of the World Bank, which he was spearheading through the design thereafter as an executive staff member during the implementation phase. He was instrumental in doing up the legal blueprint to establish ICTA as well as Sri Lanka CERT. So he's the founder director of Sri Lanka CERT and also served as a chairman in the last few years. He's also a founder director and a past chairman of the FK Domain Name Registry, a commissioner of the SEC Sri Lanka, and he's a director of Colombo Stock Exchange. He's a legal general counsel of ICTA and has developed the legal framework for the use of authentication through digital signatures and has contributed immensely through the Joint Committee for the digitalization of the stock
I will
exchange.
let you know when
He
it
served
starts.
as an expert, invited expert for the Council of Europe, the UN, Citral, World Bank, and other international entities. The list goes on and on. I can speak about him for hours. So I think most of us here in the audience know him as a lecturer because he's been lecturing widely, and he's known for being one of the pioneers when it comes to ICT legal issues, not just locally but internationally as well. He's active in ICANN and has served as the associate chair of ICANN and the vice chair of ICANN GAC for 2 terms. So, like I said, the list goes on and on. So, without further ado, I know all of you all are waiting to hear him speak. So, I'd like to hand over the controls to Mr. Fernando. So, over to you.
There's a bit of echo. Can I be heard?
Yeah, you can go, sir.
You may have to mute the mic at the podium. Can I start? Okay.
Yes, sir, please.
Yeah. So, a very good evening to all of you. Sorry, a very good morning to all of you. It's late evening here in Suva, Fiji, where I'm on a very interestingly a cyber security and cybercrime, electronic evidence, legal assessment for 2 international organizations, both Interpol and Council of Europe, our Cybercrime Convention Committee. So I'm here in Fiji, Suva, in the middle of 2 meetings, joining you today. It's amazing to see this level of interest from participants at a forum on a very important subject of significance in terms of policy development in Sri Lanka. And I'm really thankful to ISACA for taking the leadership to organize such events at a very challenging moment for our dear country. Nevertheless, let me try to do my best to deliver a broad set of overviews in terms of the adoption of the Data Protection Act in Sri Lanka and what it means to all of you who are cybersecurity professionals and want to learn further in this subject area. So the data protection legal framework, its rationale is obviously very well known. For Sri Lanka, like many other countries, were facing significant issues in terms of legal barriers and non-tariff barriers due to the lack of a legal framework governing data protection, because of the fact that we had to engage in trading partnerships with a large number of trading blocks and countries globally. And one important trading bloc, of course, is the European Union. In terms of generating jobs and enhancing the potential of the knowledge and expertise of Sri Lankan talent, we had to have the ability to reach out to our trading partners and give them the comfort that Sri Lanka meets equivalent or same legal standards governing privacy and data protection. It is in that context that we have a variety of international standards that has evolved over the years, starting from the OECD guidelines, which set the foundation years ago to establish data protection legal frameworks. So we have the European Union directives, we have the WTO standards stemming from the General Agreement on Trading Services, as well as the European Data Protection Regulations and the Council of Europe Data Protection Convention as examples of international standards, and not to mention the fact that in the Asia Pacific region, we have the APEC, Asia Pacific Economic Community Privacy Framework, which sets benchmarks for countries to follow in terms of data protection laws and policies. Now, the lack of a legal framework, as I said, was a non-tariff barrier when we engage countries which required us to follow minimum standards. And very often we have seen many companies not being able to get into the final round of selection, despite maybe getting shortlisted. They were not able to get into the final round of selection because they were operating from a country that did not have same or equivalent standards relating to privacy and data protection. So to cure these problems, Sri Lanka has been working over the years. Our Law Commission published a paper more than 10 years ago. Ministry of Justice had some legal frameworks drafted. Central Bank as well as other stakeholders were in the process of formulating legal principles on this subject. However, in February 2019, the Ministry of Digital Infrastructure, together with the Central Bank of Sri Lanka, gave some kind of a created a kind of an urgency to get this thing done, and entrusted the responsibility to us. And we formed a joint public-private expert drafting committee that consisted of the Ministry of Justice, Legal Draftsman's Department, AG's office, together with private sector experts who added value in the process of drafting of this legal framework. So in terms of models we followed, I have given the various options and frameworks we looked at in the second bullet. But what is even more important is what is stated in under the third bullet, namely the transparency and stakeholder consultation process, resulting in numerous sectoral reviews, which help to improve the quality of the law. So, for example, SLASCOM, FITIS, Ceylon Chamber, and number of other stakeholders had several rounds of discussions on the subject, together with the Computer Society of Sri Lanka. We had experts from the fraternity within ISACA also giving inputs to the process. Then we had several rounds of constitutional review over a period of 18 months. And then the bill was published initially in June 2019, further improved at various stages thereafter, and was first submitted to cabinet in December 2019. And thereafter, the constitutional review process went on for another 1.5 years, and then placed in the order paper and debated and approved. There were issues and challenges along the way. I don't say one can have a perfect law in place in terms of rights of data subjects. We have done the best we could achieve. However, there were other considerations that were raised in terms of balancing right to information versus rights to protect individual privacy, which is of course a interesting debate taking place at an international level. Either we could have waited until these debates are being sorted or adopted something of a compromise for course correction later on. Nevertheless, the bill was finalized and adopted. So what is important here to note is that in terms of the purpose of the data protection law, it provides for the framework to regulate processing of personal data. I will come to the definition of personal data, and to identify and strengthen the rights of data subjects. And then more importantly, to set up a separate regulatory authority for data protection. I would also like, I think some of you may have already downloaded a copy of this act, the Data Protection Act of Sri Lanka. If you have a look at the preamble in the first page, you will see that the primary policy goal is to facilitate innovation in the digital economy and to improve interoperability between personal data protection frameworks, including cross-border cooperation amongst authorities responsible for protecting and enforcing data protection laws. So we are talking of cross-border data flows, which will take care of some aspects of trade-related matters going forward, where there has to be some kind of a relationship, not just only between the South Asian data protection authorities, but at an international level, so that we create a framework for cross-border data flow as well, with checks and balances. So this is something we tried to achieve with a lot of stakeholder discussions. And I must also mention that in the finalizing of the law, we also got a lot of input from experts from the European Commission, as well as the ASEAN Secretariat as well. So in terms of the definition of personal data, you can have a look at it later. The definition encompasses information that can identify a data subject in relation to various identifiers that we are aware of, right? Identification number, financial data, location data, even online identifiers. This act also encompasses a special definition for special categories of data for which special governance standards would apply. Special categories of personal data would include health data, DNA records, and biometric information kind of aspects. But what is important is that the law is all about protecting personal data of data subjects who are known to be identified or identified natural persons, alive or deceased, and not company or intellectual property information, for which there are separate legal frameworks governing how those will be protected. In terms of the application of this act, I must emphasize it is quite broad. Maybe some might argue it's quite extensive for the reason that it covers processing of data where the control of processor is located in Sri Lanka, or even if they are outside Sri Lanka, if they are offering goods or services to data subjects in Sri Lanka, or specifically monitoring the behavior of data subjects in Sri Lanka, including profiling with the intention of making decisions in relation to the behavior of data subjects, then of course all of these entities such as Facebook, Google, Apple to Microsoft would also be regulated and governed under this act. That's why during the public consultation phase, we were mindful of the extraterritorial impact these policy measures would have on the country, and we engaged in a healthy debate and a dialogue with all these international providers including through the Asian Internet Coalition, which provided very valuable, extensive written submissions that helped to improve the quality, so that we created the platform for harmonization, where all these international business players could coexist with local players in a non-discriminatory manner, so that Sri Lanka, one fine day when we recover, will be ready to do effective business and improvement in terms of high quality processing within Sri Lanka. So this law is basically about having certain rights. I define whose rights are protected, rights of data subjects in relation to personal data and special categories of personal data. Then the question is, in what context? So the context is set in terms of the controllers and processor relationships that we are aware of. I have given in the middle bar the various types of relationships that can happen in terms of government data processing. We know what the NIC Department of the Identity Card Department is there all the time processing data in terms of giving us an output, namely identity card, or the Immigration Department would process our personal data to produce a passport. Then we have schools where our children are admitted, where the parental and children's personal data, including our address, email ID, telephone details, are captured. Supermarket chain, where you get a loyalty program. You subscribe to a loyalty program and give all your personal data, including your NIC or your mobile and other details. And in all these scenarios, you find those entities, namely Identity Card Department, Immigration, the school, the supermarket chain, then even a bank that collects all our data through the banking mandate before we become a banking customer, or we subscribe to savings deposits. In all those scenarios, those entities will become the controller within the meaning of the data protection law. A controller, as defined in the Act, is a natural or legal person who decides the purpose and means of processing personal data. And then the controller would also outsource some activity to another entity called the processor, which would be a natural or legal person who process personal data on behalf of the controller. Now, this is very interesting, and the dimensions of cooperation and collaboration and the relationship is governed by the provisions of the Data Protections Act. Now, in terms of the scope of the Act, I will not go through all of these because I know you have a long day and we started late. But to summarize, broadly, the principles of data processing, including lawfulness, and I will come to transparency as well as accountability, confidentiality, integrity aspects, because that relates to information security. The principles of data processing are found in Part 1, rights of data subjects in Part 2, and the obligations of control and processor in Part 3. Of course, we have other provisions governing cloud hosting. I will come into that in a few moments. But if you look at lawful processing, the part 1 of this Act, there are a number of features that intersects with information security as well. So, for example, I will go briefly through one by one. If you look at lawfulness of processing, Section 5, the criteria for lawful processing of personal data is described in Schedule 1, the conditions for that lawful processing. Then when it comes to conditions for lawful processing of special categories of data, they are found in Schedule 2. So in terms of Schedule 1, for example, we must remember consent of an individual is not only the basis for lawful processing of personal data. You might have contractual frameworks that we might enter into in a banking environment, in a mobile telecommunications customer onboarding process, to a number of other scenarios where value-added services may be given by entities, where you subscribe to certain terms and conditions, and the contractual framework will govern lawful processing. So that is also given recognition to in our law as a means for lawful processing of personal data. And when it comes to special categories like biometric data, there are additional conditions that one must meet. Before I jump to section 12, the data protection management program, I just want to emphasize that the Data Protection Act has got some unique features, namely section 11 contains the transparency obligations that may have to be complied with by controllers and processors going forward. So what that means is, if you look at section 11 and read it in conjunction with schedule 5 of the Act, you will see broadly the parameters for a privacy notice. So those of us who are used to doing standard cut and paste privacy notices, please take note that once this law is brought into operation on a later date, maybe latter part of next year or thereafter, you may have to customize and improve on your privacy notices in compliance with the transparency factors contained in section 11, read with schedule 5. Just take note of just one small point in that connection. And in terms of section 12, what I want to highlight is that this Data Protection Act, there were companies and corporations and international players who were concerned whether it would entail too many obligations and burdens which would incur additional costs. So the cost of implementing a law like this was very much in the minds of the drafting committee. So what we did was to hit some kind of a compromise by bringing in provisions contained in the data in section 12, which broadly refers to a data protection management program, basically an internal governance framework that an organization can put in place to regulate and manage the processing of personal data in such a manner that they would be compliant with the Act. So it's a self-governance regime that has been introduced that will ensure that the personal data is duly processed properly, that there would be encryption, anonymization, and other access control measures for data that needs to be specifically protected. Then it would have integrated to governance structures of the control in terms of organizational aspects and internal processing connected to the operational manuals, then link it if required to data protection impact assessment programs, and conduct periodic monitoring and assessments to ensure compliance with the Act, and then to even have oversight mechanisms to receive complaints and conduct domestic inquiries. All these facets have been brought in through this data protection management program under section 12 to ensure self-governance program, which I think is an area that would definitely intersect with the work and the theme of today's deliberation hosted by ISACA. So that is an important point I just want to highlight. In terms of other features of the Act, you have the rights of data subjects, which are described under Part 2, that ensures that the individual would have the right to access and know what kind of personal data we have about ourselves with organizations, the right to rectify our information, like if there's been an address change, to require a public authority or a private entity to amend our records accordingly. But remember, there are features like right to erasure, but these are not unilateral rights. A government entity or a private entity can refuse to comply with those requests on grounds such as the ones which I have mentioned in these slides, and there are rights and procedures available for appeal to the regulator and thereafter to the Court of Appeal. One important facet to also take note is that unlike some other countries which have only applied the data protection regime only to the private sector, this law applies to both public authorities and to private sector in a non-discriminatory manner. So, for example, in Singapore, their law applies primarily to the private sector, and their Data Protection Act does not apply to government entities because there's a separate regime governing processing of personal data within government entities, right? It's not the Data Protection Act. So in terms of broadly the controller process obligations, remember, it is not necessary for all organizations to have a DPO office. It is good if you have, but it's not compulsory. There is a test in section 20 with regard to the kind of entities to whom the requirement to have a data protection officer would apply. So, for example, if there is if that organization is regularly monitoring, having systematic monitoring of data subjects on a scale and magnitude that will be prescribed in a subsequent regulation under this act, and there is regular processing of special categories of personal data, like in a private sector hospital, then processing which results in a risk or harm affecting individuals. In those scenarios, mandatorily you need to have a data protection office. Suffice to also add that government entities processing personal data must necessarily have a data protection officer identified, and qualifications and criteria and responsibilities are also stipulated under this act. Now, this is an important provision. I'm at the very end of my set of slides, but I would like to conclude with this in a couple of important points here. In terms of cloud hosting of personal data, which has become an important point of policy level discussion, be it at the central bank or Securities and Exchange Commission or capital markets or financial institutions. The question is whether we can host our customer data outside the country. So section 26 defines the boundaries within which it can be done. It is called cross-border data flow. It provides a lot of flexibility, unlike many other regional laws. So to summarize, government entities processing personal data pursuant to a legal obligation imposed under certain laws, that information has to be localized. So this would apply to identity card department, immigration, RMV, and such similar organizations. But when it comes to private sector entities, including banks and many other organizations, there is more freedom provided. There's a great opportunity for cross-border data flow for government entities, so for private sector entities, including public corporations, including banks, which are government-owned, would have greater flexibility. But remember, such entities engaged in cross-border data flows or hosting data in the cloud will have to comply with certain minimum standards prescribed in the law, including ensuring compliance with binding legal instruments that will be prescribed once the new data protection authority is established, right? Lastly, in terms of enforcement and implementation, will be in time to come, maybe in about maybe 1.5 or 2 years. Hopefully, a new data protection regulator will be established. The criteria and its scope has been clearly described within these sections. There is the ability for this entity to also license certain classes of activity, specifically in the domain of identity management and services related to identity management, because that has been a very important policy touch point across many evolving countries, which are increasingly providing identity management services and authentication products, which can result in more higher risks for individuals. Again, this is an area where cybersecurity and information security interplays nicely with privacy. So privacy professionals will have to interact with cybersecurity professionals to ensure a safer and well-governed ecosystem for such identity and authentication activities to happen. So we have included a licensing framework for that, with specialized committees to be appointed to recommend the criteria and model for licensing. So some unique features in that connection is that we would have hopefully sectoral guidelines, rules, etc. formulated by committees, and unlike other regulatory laws where the rules are published and only when it is published and gazetted we know what exactly those rules are. In this act, we brought in a process where the rules formulated under the act, especially those which impact controllers, processors, as well as other operational activities, including automated decision making, those rules will have to be published, and there will have to be a public consultation before they are gazetted. So that is a unique aspect we have brought in this Data Protection Act. In terms of enforcement, finally, please remember this fine, imposition of fine and penalty. We have given a upper end figure. That does not mean that one can immediately go in and obtain a remedy through a fine. What has been done is to introduce a safety valve through section 35, that before the regulator imposes a fine, it would be required under the law to issue a directive to do course corrections regarding non-compliant entities. So it is thereafter, if you violate a directive, that it would trigger a further inquiry resulting in penalties. So what has been done in this law is to have a process of inquiry where all parties are being heard, and to do a course correction through a directive before penalties are imposed. And before the penalties are imposed under section 39, certain mitigation factors have to be looked at under section 39. And I would like to emphasize that the data protection, the effective data protection management program under section 12 is a factor that the data protection authority will have to take into consideration before imposing fine, and what remedies based on the grievance of an individual that the control or processor has already given to the data subject would also be a consideration before fines are imposed. So with that, I think I have overstepped my remit quite a bit by at least 4 minutes. I thank ISACA for inviting me to speak, although I am not in the country. Once again, I hope you have a very successful conference, and I thank you for a patient hearing. If there are any specific questions, I have one of my colleagues, Tanushi, in the audience there, and also Lakmal and many others are available. They would be delighted to provide any clarifications, or you can forward an email to me at these addresses I have given here. Thank you very much. Thank you very much for a patient hearing.
Compliance regime is in place in your corporate environment. So I will also be speaking a little bit about how this is relevant in today's day and age. I mean, this Data Protection Act is something that came about very recently to Sri Lanka. But this is something that has been in place globally and in the international platform for a very long period of time. So even though we are quite new to whatever is happening around, maybe not knowingly, we have already had some safeguards. Data protection. So why is it relevant now? the need for consumer protection has also enhanced in terms of scale and scope, along with advancement and expansion of the technology. So, unlike earlier days, the consumers that we have expanded over to online transactions as well. And it is up to into the wrong hands are not for the purpose that they have been given by the data owners, and it is the responsibility of the corporates to ensure and the usage is limited only for that purpose that they are being given to. Building customers' confidence is imperative. So especially now in this day and age, even the people, the customers, the consumers are more aware. They're more aware of their rights. They know what is out there. They're being exposed to all these data breaches, misuses, and sometimes there are occasions where we would just all of a sudden we would get a message from nowhere and we have no idea why we got the message, and to see that has only because the customer's information, the phone numbers or email addresses have gone the knowledge of the customer. So the consumers and the customers are very well aware of these developments. They know that the data that have gone to another party has only happened because with the knowledge of the corporates, and they're very well aware of their rights as well. So especially in this era, especially where the digital inclusion is very much in place, especially post-COVID, it is really important that the corporates are well aware of how to protect the consumers' rights, especially if counter the developing countries in least developed countries. More than half of the a year ago, according to a 2019 survey. So even after COVID, we can only assume that there has been a rise in this pattern, because more than earlier, people are more aware of the technology, even in Sri Lanka. I think with COVID-19, we saw an increased usage of technology, especially even the ones that never used a smartphone or never had access to internet. They all had to restrict themselves to the technology because there was online studying and online trading and so on. So everyone is now very much aware of what is happening in the world now that it has been 2 years. I would say. Really important. But now the Data Protection Act, like Mr. Fernando mentioned earlier, it only enacted on the 18th of March 2022. So before the Data Protection Act came in place, I mean, it's still an act. It has already become a legislation, but the effect or the operation of the act has not begun yet. So there has been a grace period given for the companies to adapt to it, to build their methodology, to develop the systems to suit the data protection. Systems and so many methods in place by the companies, especially online traders, which actually talk more about the self-regulatory aspect. So there are self-regulations which have been put in place by the consumers, by the corporate entities. So there are features such as do not call list. So especially in US, there are a special do not call list where the consumers have informed the authorities that they do not need to, they do not wish to be called when there is a promotion, or if there is going to be any sort of an advertising marketing campaign, they do not wish to be called upon. So they are placed in a do not call list. And then we have consent to message. I'm sure most of you would have seen sometimes when you get emails or sometimes when you get messages on the phone, there's a small caption, a small lettering that says at the bottom, if you wish to stop this ad, please say no and send it to this number. Or sometimes there are emails. There are many promotional emails that come to us. We have no idea where they come from, but sometimes we can say, I do not wish to subscribe to this. I do not wish to get any promotional emails. Sometimes when we, even when we get any information from a website, we are asked to tick some boxes, like whether you wish to get any newsletters or whether you wish to be contacted for any marketing promotional materials. Then you have the option to tick off and you have the option to consent to whether your information can be given out and whether those information can be shared by with a third party, by the corporate entity that you're giving it to. And also there's a transaction verification which goes hand in hand with passwords and OTP. We all know that sometimes when we do online banking transactions, we are asked to give our password and then we get the one-time password. So these are also protective mechanisms available to by a third party. And then of course encryption of data, which we are all aware of. And then we have the opt-out provisions in user agreements. So if these are actually the things that most of the people don't look at: the privacy policies, disclaimers, terms and conditions, the user agreements. These are all available in any website that you access. So if you policies, and if you look closely, there are certain terms and conditions which specifically says how this data is used, where the data is stored, whether it's stored locally in a cloud environment or whether it's stored outside the country, and how the data will be utilized, and what are the kind of data that they will be collecting. So most of these aspects are covered in privacy policies, and even the disclaimers. Even the terms and conditions. The terms and conditions specifically talk about the content of the website and how the information is used, what are the information that the user will be privy to, and most importantly, if the user is to divulge any information, then how that is going to be protected. And then along with digital signatures and biometric identification, these are all protections offered to the user of an online platform to make sure that the usage is legal. If we talk about privacy as a fundamental right, it is not directly, or it's not a clearly given right in our articles of the Constitution of Sri Lanka. But Sri Lanka is a signatory to International Convention on Civil and Political Rights, International Convention on the Protection of all Migrant Workers and Members of their Families, Convention on the Rights of the Child, and Universal Declaration of Human Rights. So since we are a party to all these international conventions, international legal platform, we are bound passed in the Data Protection Act. So like I mentioned earlier, why we need data protection is because rather than earlier, now all our information are available on a digital platform and they are easily accessible. So Sri Lanka is on its way towards digital transformation. Most of the functions that we did earlier through physical means, through manual means, have now become digital. Because of COVID-19, people are more acceptable towards digital transactions rather than doing any manual work. Even the banks, they are encouraging online transactions more than before. And because of this reason, the information are largely available on a cloud platform, on the internet, and the larger the information are, the riskier it gets if the adequate protection is not given to them. And also every action can that can be traced by anyone. So sometimes when we do a Google search on holiday homes or whatever hotels that we can go to, the next thing we know is that as soon as we log into Facebook, the sponsors, the advertisements are appearing out of nowhere. And we cannot understand the connection as to why this is happening. But the thing is, we are already accessing the internet. We are using the same portal to access all this information. And the more information that we give out to the internet, the traceable it gets. And most of these data are stored and traded by companies and governments. So whenever we give out our data and information to a corporate entity, there are other third-party organizations and companies who are willing to purchase those information, which they want to use for their marketing and promotional materials. This is a business, this is a trade that is going around, but if we ensure that proper data protection mechanisms are in place in our corporate institutions, then to make sure that the the customer's data are not spread, are not gone. So this is the responsibility of the corporate entity when a customer gives you data to make sure that they are protected in the best way possible. So we also come to the Data Protection Act number 9 of 2022. The purpose of the act, as mentioned by Mr. Jayantha Fernando, is to provide for regulation of processing personal data. I'm not going to go into details of the purposes and everything because it has already been discussed earlier. And strengthen the rights of data subjects and to provide for the establishment of the Data Protection Authority. And most importantly, this is an act which has been established to ensure that the digital economy is transformed and improved in the country, because due to the lack of a Data Protection Act, most of the foreign entities, international organizations were not willing to invest in Sri Lanka because the customer data, the level of protection offered to the customer in a company is not ensured. And these are all the organizations who are in compliance with GDPR and other international laws and regulations. So in order to be in par with the international standards, now we have a Data Protection Act in place. And hopefully when things get better in the country, I'm pretty sure that this is going to be a value addition for the country, especially when bringing in more revenue from the international platforms. The operation of the Act, like I mentioned earlier, this is not in operation at the moment, but there's a staggered implementation of this Act, which means that this Act will be implemented part by part. So all the other provisions of the Act, except for the provisions of Part 4 and Part 5, that is use of personal data to disseminate solicitors' messages, and then Data Protection Authority. Apart from those two acts, the other provisions of the Act will come into place, will come into operation on a date between 18 to 36 months from the date of endorsement by the Speaker. So this Act was enacted on the 18th of March, and there's a minimal time period of 18 months for the companies and the institutions to put their compliance requirements in place, to do the preparations to prepare for this Act. And after the 18 months have passed, and before 36 months expire, the operation of this Act will commence. And when it comes to the use of personal data to disseminate solicitor messages, that will come into effect from between 24 to 48 months from the date of endorsement. That is again 18th March. So there's a longer time period for implementation of that Act, that provision. And then the date of operation of the provisions of Part 5, that is about the Data Protection Authority, that will come into place after the 18 months have expired, but not before 36 months. So once the other provisions of the Act have come into operation after the expiry of 18 months, then only the Data Protection Authority will come into place. So there is true, I mean, when you look at it from this angle, it has only been about 3 months, but 3 months have already passed, and we only have about 15 months to go. That is given the earliest. But there's a lot more that the entities should take into consideration and make sure that the guidelines are in place. And this is the time to prepare until the Act actually comes into operation. So the personal data definition, of course, this was highlighted earlier. And the personal data means any information that can be used to identify a data subject. So a data subject is a natural person. That is not a company. So a data subject is someone like you and I, even the child or a deceased person. So if it is a deceased person whose data has been compromised, then the heir of that deceased person can file any action, and they can appear on behalf of that data subject, because there are occasions, I mean, we have seen sometimes this usually happens during elections where the deceased person's card has been used to vote for some other party, and there are all these things that are happening around. And also sometimes the deceased person's accounts those information can be taken. But if the person is deceased, then the heir of that person can come and claim the rights of that data subject. And the personal data is anything that can be used to identify a person for who they are. So it can be a name, an identification number, any financial data, that is any account details or whatever. Then the location where you stay, address, and any online identifier, that is it could be your usernames, passwords, so on. And all these things which can ultimately route back to the original person where a data subject can be identified, those details are known as personal data. And also there are other data categories, some which fall into the parameters of personal data, and some which fall into the definition of special categories of data. So there are different methodologies that needs to be used to process personal data, and there is a very specific methodology that needs to be used when processing special categories of data, because they are more sensitive information and that needs more guidance and specific methods. The personal data which can identify card number, this could be an account number, that is a savings account number, customer's ID, all those. Which relates to the personal data relating to genetic characteristics of a natural person, which gives information about a person, about the physiology or the health of that person. So this could be a blood sample, or it could be a part of your hair or bodily fluid or a natural person. And then we have biometric data, the fingerprints that we use, and the iris, everything that we use to sometimes access information and access any personal accounts. So I mentioned about special categories of personal data, and the data types that I told about, genetic data and biometric data, are considered as special categories of data because they are very sensitive information. And these specific conditions to process special categories of data come under Schedule 2 of the Act. So Schedule 1 talks about processing personal data. There's a special Schedule 2 which talks about processing of special categories of data. Like I mentioned earlier, a data subject is a natural person and identify the natural person alive or deceased to whom the personal data relates. So I have told you that if you are alive, then even if it is a child, even if it is not an adult, then even the parent on behalf of the child can claim these rights. So this is applicable to every person, living or dead, and cover. So something that needs to be kept in mind is the distinction between the data controller and the data processor. So legal person. And why the data? We need these data processor who instructs the purpose of retrieve. So the data say a person, I will take the example of a bank. There is a customer comes and the card to the employer, to the bank, to the teller, and then the bank actually takes in those information, and let's say he wants to apply to a credit card. Most of the time what happens is there are separate third-party entities who have been outsourced to carry out credit card operations, and the bank then gives this information to the credit card company who will do the processing. So the employee who is employed at the bank, who takes the information and feeds it into the system, agreement taken and why we are using this. He will still be under scrutiny by the data controller. So what will make this process between the data about needs to understand is that there's always going to be the compliance requirement in line with the Data Protection Act. So if we say that the data controller and the data processor will be bound by the data protection laws and any other laws and regulations that come into place in relevance to that, then it means that all these provisions are that you can use as companies to go that extra mile and make sure that you have taken more than adequate protections to more than adequate steps necessary to protect your customers' data is something that you can develop internally and which goes beyond the prescribed mechanisms under the Act, and that can be covered in your contract. And even the obligations from the data controller to the data subject, that can be captured in the terms and conditions, because again, I will take the banking example where when a customer opens a bank account, then you are given a terms and conditions in the, you are given the KYC and everything. And then you have to specifically mention why the bank requires all these documents, and these are the steps that we are going to take to make sure that your data is protected and are well stored. It's not going to go into the wrong hands. They will not be misused. So all these things, when I say contract, it actually means terms and conditions and the privacy policy. So this can be applied across all industries. and a simple contract that will be drafted in line with the data protection compliance mechanisms will ensure this protection to the company. And then we have the controller's obligations. So especially in a contract, if you say there are obligations of each party. So these are, when we say the contract is drafted in line with the Data Protection Act, then these mechanisms will be covered automatically. But this is actually the starting point. This is the minimal level expected from the Act. But you are very much welcome to take added protection to make sure that you have gone that extra mile to protect your customers. So there are obligation to process personal data in a lawful manner. This was discussed in detail earlier. We need to define the purpose for personal data processing. So you need to be very clear as to what you want to do with that. Confine personal data processing to the defined purpose. You cannot use the data for any other purpose than it was retrieved for. They need to ensure accuracy and to limit the period of retention. So you cannot hold the data for a very long time. Even if that becomes obsolete or if the information becomes false, then you have to make sure that they are always accurate and they are always corrected. Obligation to maintain integrity and confidentiality. Of course, it's a fundamental requirement in compliance. And to process personal data in a transparent manner. So the data subject should always know how these information will be stored, gathered, and they will be used by these companies. And then the accountability, which was discussed in detail by Mr. Fernando, that each company should maintain that there's a data protection management program to make sure that all the internal controls are in place. And also there are specific obligations of the processor. Even though the processor is very much carrying out an independent role, he still has obligations in his hand, even though the majority of the obligations fall on the data controller. The processor's obligations are also to appoint the data protection officer to make sure that there is a person who overlooks all these data protection mechanisms. Personnel to be bound by confidential and secrecy obligations, assist controller to meet obligations under Part 2. So there are certain steps that need to be taken by the processor to assist the controller to make sure that the right mechanisms are in place. And then to facilitate controller to carry out compliance audits, because at the end of the day, it is the processor who processes all these data. And as required, they need to come up with the right amount of data and to ensure that the controller that everything is going right. And then they have to comply with the written instructions of the controller and principles of processing. So they are very much guided by the instructions given by the controller. And then erase or return personal data once services are terminated. Remain liable to the controller for acts of a sub-processor. So let's say this has been given to a third party to process the information and they have outsourced it to another party. Then again, at the end of the day, it's the processor who is liable, because it is with the processor that the initial contract was made by the data controller to process the data, and whatever is done by the outsourced company is also ultimately the responsibility of the the principal data processor. And any other contractual obligations to the controller. Those are the extra methods and extra precautions that the companies can take to make sure that you have added protection which goes beyond the Data Protection Act. And then as data subjects, there are several rights. Right of access to personal data. You have to have the ability to access your personal data at any time. Then the right of withdrawal of consent and right to rectification or completion. So if the data that are stored are incomplete or if they are not correct or inaccurate, then the data subject has the right to demand that the data needs to be rectified and they need to be corrected. And if the data subject is not comfortable with having the information up there, then he has the right to erasure. And then automated individual decision making, that is, if there are any process done by the data controller where an automated transaction has happened and that is not in line with the data subject's rights, then he has the ability to request the controller to reverse that transaction. And then you have the right of appeal. If there is any decision that has been taken by the controller or the processor, and if the data protection authority has not taken any proper mechanisms to rectify something that goes against the rights of the data subject has the right to appeal for that. So this helps the consumers mostly by the security of personal data and the collection, protection of their personal data, and this will avoid misuse by the external parties. And this can avoid unsolicited messages and ensures data privacy. But more than the data subject itself, we need to think about the advantage it will pose to the companies and corporate entities at large, because this will help the data subjects or the ultimate consumers to develop confidence in the company. If you have gone to the front and said, look here, this is how we are going to protect your information, this is how we are going to store it, you can rest assured that we are not going to use this for any other purposes than we have right now, then nothing gives confidence boost to the data subjects than a company who can take responsibility. So this not only serves the data subjects, not only serves the consumers, but even as a responsible corporate citizen, this will improve your reputation, this will improve the level of integrity, and as a corporate personality, you will be recognized in the market as a responsible corporate citizen. So not only does this protect your customers, but in turn, this will affect your corporate stature as well. And you will be recognized as a responsible citizen, which can definitely add value to the brand name as well. So the Data Protection Authority, which will actually act as the regulator, is going to come in place after the enforcement of the rest of the provisions. And I will not go into detail on what the Data Protection Authority does, but basically what they do is they will act in the role of an enforcer. So there will be directives and regulations in place. They will be enforcing, they will be monitoring all the compliance aspects of the companies, and they will be a facilitator and an educator. So there will be trainings and there will be awareness programs that will be done by the Data Protection Authority to make sure that done to ensure and a regulator. So there's a regulatory aspect which actually is highlighted more than anything, and then also act as a supervisory role. If you talk about the future of consumer privacy, I mean, now that we have the Data Protection Act in place, this is something that we need to keep in mind, like I mentioned earlier at the beginning of my presentation, that the more data that is exposed to the public, the more data that is exposed to the internet actually, the riskier it gets, because more data means more value. And the more data is gathered, then the value of that increases and the level of protection that it requires is also higher. Because nowadays there is the artificial intelligence mechanisms and machine learning algorithms that often require massive amounts of data to function, to pre-train them and establish patterns. So they can identify the behavioral patterns and they can identify the market requirements and the model intelligences. So they are based, they actually thrive on the personal data of individuals, and they are actually called data hungry AI technologies because they solely depend on the data of the public. And in the future, there's a prediction that the global AI software market is expected to grow dramatically according to a research from Practica. This was published in 2019. So this will increase from an estimated $9.5 billion to 118.6 billion by 2025. So you can understand the amount of responsibility that the corporate citizens will have to make sure that the customers' data are well protected at all times. So these competing trends of advanced data collection technologies will also lead to increased expectancy of protection, and there will be requirements of transparency because the data subjects and consumers are more aware than before, and due to that we need to take more precautions in protecting the data. So in summary, I would say what we need to know is that the protection of consumers, especially from online fraud and mismanagement and misuse of data, is going to be an integral part of any of the regulatory policy of any entity. And again, what should happen is consumer education. The data subjects need to know exactly what the rights they have, and their rights and obligations should be at the center of policy making. So when you are imposing internal controls and when you go to self-regulate your companies, then something that needs to be kept in mind is that is whether the consumer's rights and obligations are protected. And also cross-border cooperation needs to be in place among regulators. The regulators and the need for caution so as to avoid any hindering innovation and growth of digital services. Also, there needs to be robust data protection frameworks, which I have emphasized again and again, and new approaches on regulatory governance, especially cross-sectoral collaborations, because there can be occasions where sectors can intersect, like health can intersect with insurance and banking and so on. So there needs to be a collaborative effort in all these industries to make sure that the consumers' rights and their data are protected at the most. And of course, the self-regulation along with the regulatory backing provided by the Data Protection Act. That comes to the conclusion of my speech. Thank you very much for listening.
Thank you, Thanushi. Next we have Mr. Nalin Vijaytilaka, who will be speaking to us on the topic Global Context to Privacy Legislation. Mr. Vijaytilaka has over 4 decades of experience in the field of IT security, governance, privacy, and business continuity management. Mr. Nalin was ISACA Hall of Fame inductee in 2022. He's a director and principal consultant at Continuity Limited, an esteemed organization in the field of IT security based in New Zealand. He holds an MBA from the University of Jawaharlal, a postgraduate in business management from TIM, and a PhD in business management from the University of Oulu. He also holds a range of professional qualifications, including CISA, CGEIT, PMP, CBCP, Certified Data Protection Officers from PECP, and he's also a fellow member of the Business Continuity Institute. So with that, I'd like to hand over to controls to Mr. Vijay. So,
hello.
We can hear clear, Mr.
Yeah, and I want to share my slides.
Yeah, please go ahead and share.
Yeah. Just a minute, please. There's a problem in. Can you
try to share now, Ms. Nalin?
Yeah. Is it coming?
Not yet.
No, no,
Yes,
no.
It came in.
Ladies and gentlemen, looks like Mr. Vijay Tirthy is encountering a few technical issues. We'd like to go for a tea break now. We'll do a bit of testing. So let's go for a tea break now and let's meet at 11. So that's 10 minutes from now. Till then, we'll do a few.
Nalin, can you share the screen?
Yeah. Yes. This is the wrong one.
Yeah, no, it's coming. I think we can continue. Okay, we went again. Yeah. Yes, okay.
Thanks.
Yeah.
Ms. Nalin, I think.
Yeah, there's a
Yeah.
issue with regard to.
Can you see if you can share so you can test it?
Yeah, that's what because it is
Don't
not
close.
coming up.
Close the browser.
Some others,